Cornwell, certified nurse midwife with Midwifery Business Consultation. And I have Isi, famous Isi with Contemporary Insurance. He's so gracious every 3 to 6 months to give me a half hour, 40 minutes of his time. Thank you so much for being here today, Isi.
Good morning. Enjoy talking with you.
So if you want to just give a high level introduction, because we've done 3-4 of these. So if they want the full introduction, they can watch your first video, but just at least if this is the first time meeting you.
Sure. I'm Isi Teitelbaum. I'm actually, in my former life, was an attorney, but now we are selling medical malpractice, and we insure midwives, physicians, nursing homes, clinics, many types of, almost everything that's in healthcare, telehealth or otherwise, we insure. We have specialized programs for midwives. We've had this program continuously for 40 years. It's the only long-term program. We have been with 2 different insurance carriers during that time, and even in high markets and difficult markets, we've usually been able to find coverage for our midwives. We insist in the carriers that we work with that the midwives dictate the terms of how they practice, not the insurance companies, which is also extremely unique. And the other provision of the policy that we find very, very advantageous to our midwives is that if a tail needs to be purchased, it's actually something that many midwives can handle on the premium. So it's not something that leaves you bare if you need to do it. So there's a lot more bells and whistles, but and the last thing is that our attorneys are so well versed in midwifery practices and medicine is that they actually sound like midwives. And when they give defenses, the midwives really feel that they're being protected. So all in all, we're very happy with the program. And we also sell outside of our program. So we have both choices available to us.
Well, and I think it's amazing. I talk all the time with my consulting services of like, it's one thing to hire an attorney, an accountant, but to someone you got to pay to now explain your services and what you do and what you are, to have someone advocate for you that actually lives and breathes it. I mean, you've talked in other ones, your kids have had midwives, you love midwives, we can tell who's passionate about midwifery and who it's just like, okay, if they can't find anybody to serve them, I guess I'll serve.
Yeah, well, our youngest granddaughter had a home birth, caught our youngest granddaughter in her hands by herself with a midwife present, and took our granddaughter to her breast and nursed her, and it says that it was the best joyous experience of her life. So
yeah, and the hard part is the evidence and data. When you and I talked before we started recording about sometimes the numbers and analytics of malpractice doesn't give a calculation for the personal empowerment and the ripple effect of the bonding, and there's no numbers to those things. So it's very hard to give a quantifiable value to it. What are the other things we were talking before we hit record of, like with COVID and a lot of the malpractice is getting so expensive and there's more additional clauses and things. You had some really great insights for midwives of like how much control do they have when they're negotiating a malpractice coverage, or do they just take what they can get because there's not many options out there?
So a lot depends on whether the midwife has choices in the coverage that she's purchasing. So if she's working for someone else, the employer may dictate the coverage. If the employer is dictating the coverage, the only choice that the midwife really has is to take the job or not take the job. She may well be able to convince her employer to let her bring her own insurance with her, but that is probably only a 50-50 chance that the employer will permit that. Having said that, there are wide differences in the policies that are available individually to midwives. So for example, some companies will only cover VBACs in a hospital. Some will not cover VBACs at all. Some, like our program, covers VBACs in any setting. We trust the midwife to make that decision. We recognize that things can go bad in any delivery, whether it's a VBAC or not a VBAC delivery. We really feel that we wouldn't be insuring midwives if we didn't trust their decision making. So those types of things. So the VBACs, water births is a bugaboo for some insurance companies. Other insurance companies, for example, back on VBACs charge per VBAC. We think, oh, that's crazy. So that the midwife should be able to make the choice and should be able to practice the way she wants. But that usually is only going to be available if the midwife is purchasing her own coverage.
Right. Well, and when you were talking, my business mind was going with employer, like you can always get creative if it's a private place, not a big organization, that you present yourself as an independent contractor in some win-win relationship where you would be able to bring your own coverage, but each state is different. So there's creative ways to, if you feel cornered, like I really want this job, but they don't do a tail and they don't have an option, like just advocating that midwives can ask questions and it doesn't hurt to, the worst they'll say to you is, no, that's not an option. So I think it's about empowering midwives to speak up, or even just ask questions about the coverage they're potentially getting and just saying, yes, I'll take it, because they don't realize what's a tail, what are the levels of coverage and exclusions. And I know you help people with that. You're more than happy if they're getting a job to kind of understand the coverage that they potentially are getting. You're really
That's
helpful.
correct. That's correct. I mean, I think you have really summarized that really, really well. General rule of thumb is, as long as you're getting tail insurance coverage, that you're not going to be hung out to dry when you leave. Free insurance is always better than insurance than you have to buy. So if you're negotiating for a job and the salary is, let's say, $120,000, and you have to pay $10,000 for malpractice insurance, or your employer will pay it and will guarantee you a tail or continuous coverage, don't waste your $10,000.
Yeah.
But we've heard people advise otherwise, that you should have your own protection. Not correct. You just want to have adequate, good quality protection.
Yeah, making sure it's covering you for what you're looking for and what your specific needs are. Because I think the tail is the biggest one, because a lot of people, being new, young midwives, I did the same thing, where you had the option to buy it afterwards and you're kind of laughing after a couple of years of first practicing. I'm like, well, I don't have $35,000 sitting in a back pocket you don't realize till after you're exiting, not so much when you're into it, what the potential directions are.
That's correct. That's correct. And in many cases, especially if you're working for a large corporation, you actually can direct your employer to seek coverage that will not require you to buy a tail. And usually it's what's called shared limits coverage. So what that means is that your coverage is being shared with your employer. So if a suit comes in against both the physician and the midwife, you're not each going to have a separate set of local limits. Let's say $1 million, $3 million, you're going to share it. But that's okay, because $1 million is enough if that's the coverage that you have. And because you've taken shared limits, when you leave, as long as that employer keeps the policy going, you'll never need a tail. That's huge.
That's huge. I didn't even know about that one. That's a gem.
That's huge. And you just have to kind of, I mean, you're right. If a midwife calls me, whether they're going to buy a policy from us or not, we're happy to provide advice. We know almost all the carriers that are out there. So if it's, for example, if someone's negotiating with the hospital system, we know there are self-insurance options and how the captives work. If someone's negotiating with someone that, for example, has a policy with a doctor's company for the practice, and they will also insure the midwives, that shared limits issue is very, very strong. And those are all things that you can ask for. Now, on the other hand, some of the hospitals will require the midwives to have their own limits. And that, so the question is, do you want to push back on the hospital? So there's really a lot more flexibility in there than most midwives know until they get in the process. We don't charge for our time. And if a midwife calls us, we're happy to help.
Yeah, I think it's amazing. And you and I talked on a couple of videos, and I think it's important to reiterate. People will talk, malpractice is so expensive. It's so expensive. And we were trying to demystify the myths. It's the pool of the volume. It's the statistics of, if we have more midwives actually looking into malpractice, it's going to make the cost less. So in our mind, logically, it doesn't make sense. But can you reiterate the how that happens?
Right. So all insurance is pooling of risk. I mean, if you go way back to the 1800s, basically, if you had a disaster, no one person could handle that disaster. Instead, they would go bankrupt and they would lose the farm or whatever else happened.
They did it for firefighters, didn't they? When the first fires, didn't mean to interrupt you, but didn't they do it for certain occupations? They had done it before it was a public funded thing. The communities would pool together for those things. Yeah.
Yeah. So I don't know, but you sounds right.
Yeah.
So what ultimately happened is that communities began to pool. You would get 100 people together, and they would agree to each contribute a certain amount of money. So if a disaster struck and it didn't strike all of them, which usually it doesn't, then the money would be available. So what happens is, when you have an insurance company, is simply a commercialization of that pooling process.
Risk. Mhm.
So basically what the insurance company is doing is it is calculating the risk for the entire book of business that has 4 midwives. It doesn't aggregate that with physicians or hospitals. It tries to determine how much how much is it going to lose each year. It adds on top of that usually a single-digit profit. It has an overhead cost, which may be commissions to brokers or maybe administrative costs, and that becomes the premium. For midwives, the entire midwife population is not adequate to actuarially determine what the right risk is. And that's one of the reasons that you see volatility in the premiums. The profit that the companies are making are pretty fixed. They don't fluctuate much. They're looking to figure out what the risk is going to be, what the profit component is going to be, and the expense component is going to be, and to charge a premium. What they all will sometimes do is try to calculate what that looks like over the next 5, 6, 7 years, so they're not suddenly hitting insurance with double-digit increases. They don't always do that well.
Yeah. Yeah. Well, I think that's part to reiterate, because yeah, if you have 2 midwives, because that's an outlier thing for private practice out of hospital midwives. I do a lot of consultant work where we do budgets and fee schedules and talk about it's important to have that $800, $1,000 a month in your budget from day one. And my hope is we can get a momentum that, okay, in a year or 2 years, you've now got 30, 40, 100 midwives doing it, that you should be seeing that budget going down versus they're feeling like, well, all my colleagues don't have it and now they can't back me up because I'm the only one that has it. So it becomes sometimes a challenge when you're an outlier starting it new in your community.
So it's actually funny. So I know that you work with many midwives in New York, which is one of the high premium areas. You're really looking at a premium between $30,000 and $40,000 per midwife. The problem in a place like New York is if you had 100 midwives instead of 10, you might not see a decrease in premium, may see an increase, because New York is such a high risk state.
The litigation statistic, it doesn't pool each other in thick. It's just, the high litigation states.
You'll end up with a lot more risk rather than a lot less risk. And
Interesting.
I still remember, but if you speak with an underwriter, an insurance company, they will tell you that pooling a lot of bad risk isn't better than single good risk. So it really depends on
the state location and the litigation climate. And then always enticing people, are you flexible about moving?
That's a real question, because just moving out of the 5 boroughs in New York to upstate New York, maybe an hour out of the boroughs, cuts your premium by more than half.
And people don't think about that. We think about where's the midwife regulations, where's the most autonomous place to practice? Can I run a business? Can I have prescription? Are there nurse midwives? Are there CNMs? Nobody's ever talked, well, I'm going to move to this state because the insurance premium is half the cost.
That's right. That's
yeah,
right.
because we just think it's expensive. We're just like, high is high. So I think that's important for midwives to hear, because if you're flexible, you're going to just start your practice. You have a few family areas, even like you talked about moving in an hour away from a more concentrated litigation area can have a huge impact. So having these discussions with you when they're planning their business is really helpful. Correct.
It can also decrease your income. So you would expect that moving out of the 5 boroughs in New York, you would end up charging less. So the model, and I'm sure, Leslie, that you're very attuned to this, you have to take a look at your reimbursements and see whether the reimbursements support the higher premium. And then you have to do your pro formas to make sure that your anticipated revenue will cover your costs. And those are really what make you guys important.
Yeah. Well, and the interesting part is with COVID and the demands, the midwives across the country, I've seen increasing their costs 20, 30% just because they can't keep up. And so it's interesting, like what used to be 2 years ago, everybody was at a very similar par has been, and families are willing to pay it because they've just seen the rising healthcare costs and what pandemic has really opened up the eyes of what a midwife can offer families. So
Absolutely right. And I think it really, the work that you do really adds value. If a midwife can go into a practice with their eyes open, it makes a huge difference.
It does. Well, and I know we talk about there's different kinds of malpractice. Can we go a little bit into vicarious liability? Because I get that question a lot from clients, from my midwife consulting clients. They'll be like, well, I want to collaborate with a physician, but I don't even know how to talk the talk, because usually they'll go, if they even talk to their insurance will say it's too high of a vicarious liability risk. And how do you have vicarious liability part of the malpractice coverage that you offer the midwives? How would they navigate that term and show their value in those things?
Okay, so it's actually, you phrase the question really well, because vicarious liability is an exposure that one has for never seeing a patient. It's exposure that one has because they're supervising somebody else's work, and they may never see the patient. And that's one of the reasons when you speak about collaborative physicians, many states obviously require collaboration. And I know that the midwives are pushing back against that, to have the same ability to practice free without that across the country, which certainly is something that is desirable. But the collaborating physicians always want to know that if they get sued for something the midwife does, that they'll have that coverage. Different companies approach that in different ways. So in our program, unless it's a really substantial practice, if it's a single midwife, for example, we provide coverage for the collaborating physician at no extra charge, because the collaborating physician is only being sued for the same case that our midwife would be sued for. So we have the same levels of risk, the same level of coverage, and we can tell them, and we can tell the physician that they have what's called additional insured coverage for it. Other companies will not. Some companies will not provide additional insured coverage. And that is something that the midwife definitely has to ask as part of it, because if she gets coverage, if she's in a collaborating physician state and she gets coverage that doesn't provide coverage for the collaborating physician, she's bought something she can't use because she can't practice. So, so at the end of the day, it's important. Vicarious liability rears its head in other settings. So let's say you have a 5 midwife practice with a corporation, let's call it my agency, Contemporary Insurance Services Midwifery Practice. And it is a corporation, so it is an entity that can be sued. But corporations don't have professional liability. They don't do professional acts. They're never exposed. Only a professional can get sued for professional liability, but that's not true, because at the end of the day, the captain of the ship is the corporation. The corporation is the employer. So a midwife can get sued, and the corporation, Contemporary Insurance Services Birth Practice, can also get sued for vicarious liability as the captain of the ship. So you always want to make sure that the corporation is, if you have your own midwifery practice, so if it's a solo, for example, every company out there will provide coverage for the corporation and the midwife. And you have to make sure that they're both there. If you have a corporation, you definitely have to make sure that that corporation is named on the policy. Like I say, in solo settings, it's free. If you have more than one midwife, some companies will charge extra, usually 10 or 15% for the corporate vicarious liability. We generally do not charge extra for it because it's all part of the same lawsuit again. So we will provide the corporate vicarious liability. But the same can be true if you're a hospital employee. The hospital will be sued in every case that you're sued, because it's obviously the deep pocket. And so even though the hospital may have done nothing, it's going to have a vicarious exposure. And so those are very important.
So what is the difference? So there's 2 providers, 2 midwives, one has privileges at the hospital and one is employed by the hospital. Does that make a difference for that vicarious liability to the facility? I understand, like, if they slip and fall and it's a medical equipment issue, they can't get out of it, but I believe it's the employment relationship is what gives them that risk of vicarious liability.
So you actually phrase it well. So let's take a look at a midwife that has hospital privileges and does home births. So she's credentialed at the hospital, does a birth, home birth. Home birth doesn't go well, but there's no transfer needed. It just turns out that the baby was born, everything is fine. So the hospital, even though she has privileges at the hospital, nothing happened at the hospital. The hospital has no vicarious exposure. I don't know of any hospitals that would permit an employed midwife to deliver in a home setting. I mean, there are many hospitals.
There are a few.
Are there few? Really?
Yeah.
Interesting. Okay. I haven't met that yet. I know that there are many that have freestanding birth centers, but I haven't heard of any that allow home births. That's great. So if an employed midwife is doing a home birth and she's employed by the hospital will have vicarious liability exposure because she's an employee. So they will, and you can bet that any plaintiff that sues is going to always look for the deep pocket, and that's going to be the hospital. I think we had discussed this in a previous session, that most well-heeled attorneys aren't satisfied with $1 million in coverage. They need to aggregate all of the providers, so it can be a midwife, a hospital, an anesthesiologist.
Well, in transport, they're touching a lot of fingers, peds, NICU. I mean, it's a mom and baby. They've got 2 patients. They've got a lot of malpractice coverages to tap into.
Correct. And they want a minimum of $3 to $5 million judgment because they lose so many of their judgments. They need to have the big hits.
Gotcha. Yeah. The goods and bads of our malpractice world. So I wrote down a couple of questions for you. I think it's important with each state to differentiate between collaboration and supervisory relationship, because some states will word it as collaboration and some states will word it as a supervisory. On the legal side for you, and insurance coverage doesn't make a difference if the wording is collaboration versus supervisory.
It does not.
Okay.
It does not. I mean, if we are told that the physician is reviewing files, that is interesting, but not necessarily a difference. So again, from our point of view, the physician is always going to have their own coverage. Even when we provide vicarious liability coverage, we recognize that the physician has the coverage. Now, some physicians' policies may exclude the midwifery collaboration or supervision. A lot depends on what's happening. If the supervising physician is reviewing files to get a determination of protocols and practice procedures and how an office is being run, that is a pure vicarious liability exposure.
Like a medical director for a birth center.
Exactly. Okay. If on the other hand, that physician is actually involved in the treatment of a patient, being an additional insured won't necessarily provide them the coverage they need. Then their own personal policies have to step in because they're a primary physician for that patient. That creates a significant gray area. In the 40 years I've been doing this, I've never seen that gray area become a problem, but it is an area one needs to be aware of.
Okay. And I think that's part of when the whole point, you and I are on the same page, Isi. We want to improve collaborations. We want to improve access to midwifery. And there's so many of these consistent barriers I hear, like when they want to get a collaborating physician, that those common questions come up. So I think this will be helpful for them to at least direct towards you, like, hey, their legal company that they're using for malpractice isn't familiar with midwives. Like, let's have a conversation. Our 2 insurance carriers have a talk with each other so that we are on the same page. So they don't have to know all the answers, but they can know to navigate to the experts to connect.
And you're 100% right. We actually have spoken with collaborating physicians to explain the midwife's position. And so we've had situations where some collaborating physicians refused to provide collaboration because they were concerned. We've been able to convince them that they were protected. And so we're happy to speak with the physician directly if that helps the midwife.
Yeah, I think it's just fear and misunderstanding when something's new or it's not the norm. It takes a lot for someone to be courageous and say, okay, if I'm being safe, you're being safe, we're all being protected, why not? But I think that some of the barriers the midwives say is, I can't find a collaborating physician. And it's a lot of these roadblocks where maybe there is a great doc in the area, depending if they're private practice or a hospital, that's a whole nother story. But I'm trying to remember, Isi, we had another great question on our list. I could pull up my email. I saw you looking to the side, Adam.
Yeah, we were just talking about bad outcomes and the types of things that we're seeing. And what I would tell you is that the single most frequent claim we see is failure to transfer timely. So, but the truth of the matter is that is always going to be part of a claim because most claims end in the hospital. So the question is, did someone transfer on time or not on time? So even when you see a blood matching issue, they're still going to throw in that failure to timely transfer as one of the causes of action in any claim. But let's kind of treat just that issue. The failure to transfer there are important elements to that a midwife needs to be aware of. And we may have touched on this in the past. If a midwife makes a decision that the laboring at home or in the birth center has reached a point where this patient should be transferred. That is a professional decision the midwife makes. So if the midwife says to a patient, it's time to transfer, and the patient says, no, 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 give me another hour. I think I can make this work. Okay. And the midwife, because she's a caring midwife, says another hour, but not a minute more.
Mhm.
The minute that baby is born with difficulties or the mother is hurt, she can no longer defend herself, because in her judgment, she announced that patient had to be transferred an hour earlier. The patient's judgment is irrelevant. The professional here is the midwife. So if something goes bad and the patient decides to sue, and the midwife says, well, yes, in my professional judgment, we had another hour, that was okay. I just was, in abundance of caution, was transferring early. She will lose that case because she already announced that the time to transfer was an hour ago. So if you want to say that in a way that gives your patient more time, there are better ways to say that, to say, you know, we can labor a little longer if you'd like, or we can begin transferring. Either one is safe, but we may have to transfer. But if the minute you say we need to transfer, you're done. You can't win that case.
And that's important for verbal. I mean, half of what the midwives are doing is caring for people, but I just recorded the legal tips for documentation. And I said this over and over again. If you don't write something, you didn't do it, but it's even the wording, as simple as recommended transport, you put that on there, you're hung out to dry. Or we talked about options. I recommended we're safe to stay home, or would they like to transfer at this time? It's a very different verbiage on that chart to look at later. So those are great tips for people.
And you have a delivery, while the patient laboring may not have a great memory of what happened, her spouse will, and will remember everything that was said if something goes wrong. Now, look, the truth is midwives have a special relationship with their patients. If they didn't, their premiums would be closer to OB premiums. So at the end of the day, it's not every time you say something or not every time you have a bad outcome is going to lead to a case, but you have to practice smart medicine for those that do land up in a case.
Yeah. Well, and part of it, it's very interesting to me, the clinical decision making versus the legal benchmark you're held to. So I'm thinking of emergency situations, postpartum hemorrhage, newborn resuscitation, shoulder dystocia. It's interesting to me, the clinical decision making is so wide range. Like some midwives in a home setting will say, as soon as the shoulder dystocia is announced, we're calling EMS because they take an average of 12 minutes to get here. I'd rather turn them away. And then there's some midwives will say after 5 minutes or after 5 maneuvers. Like, what is the legal system? How would you defend yourself? Is it more your consistency of practice? Because there's no evidence to say like the transport. I know I'm asking you deep questions, but it comes up often.
You're actually asking the right question, because there are two standards that are applied in a case. One is the community standard. So whatever is considered the community standard is what a midwife is going to be held to, the same as if she was an OBGYN. So if you have experts testifying that a midwife transgressed the community standard of care, that she's going to defend herself against that. The other is the protocols of the office. So generally speaking, the organizations that work with midwives have tortured over the issue of whether they should list protocols or not list protocols, with the issue being the protocols are great, but they come back and bite you if it turns out that they're used against you. But the general rule of thumb is, if you have a practice standard that you're using, and let's say the practice standard is the one that you described, 12 minutes, and that you know that you have guidelines written or unwritten that say after 12 minutes, you're going to transfer, or you're going to call for a transfer and make the decision later. The minute you break your own rules, it is indefensible or difficult to defend, because you've set your own standard. So you have the community standard of care, you have your own standard of care, and you violated one or the other. Plaintiffs' attorneys love those types of situations. And the same thing happens in my insurance agency. We have rules that we have to follow. If we set protocols and we break those protocols, that is perfect reason.
Well, and that's what's so hard with personalized care and informed consent. They're just, they headbutt each other. Right. You just have to document really well with someone like a spouse or partner involved, all the options. But yeah, it's a sticky spot, because I was thinking in my head when you talked about if you say I recommend a transport, I've had so many traumatized ladies that have flat out said to me, I'd rather die than go to the hospital. And I can't handcuff her. I can't call EMS and make her go. Like, how do you handle those tough situations? Like, you want to respect their wishes, but also, okay, I want to practice tomorrow too.
Well, actually, it's a wise question, and it actually requires wisdom to deal with it. At the end of the day, every practice has informed consents, and it has to have its patients to sign off on the informed consents. And at the same time, you don't want to get into a battle with the patient, but at the same time, you are the captain of the ship and you are the professional. So using your example, the bet to me, I mean, I'm not an attorney that represents cases, but what I would say in that setting, if you determine that you need to call EMS, you call EMS whether the patient wants it or not. The patient can decline to get into the vehicle, to the ambulance and go, but you, in your judgment, call EMS and then say to the patient, look, I'm telling you, you need to go. I'm not going to handcuff you to, to the EMT guy, but I'm telling you, you need to go. So when the EMT guy comes here, you will make that decision. I will not leave your side. So there is a certain wisdom to how you need to say these things. And the beauty is that midwives are really good at that wisdom. They really care, but they don't care enough to kill babies. And, when mothers make those bad decisions, it's a horrible thing to say. So at the end of the day, they're not asking the question of, well, 60% this way, 40% that way, baby could be injured, but if they feel baby's going to be injured, they're calling an EMT. And that should never change.
Yeah. Well, and it's interesting, just the cultural diversity across the country. I know it's hard enough for us to explain to consumers what a midwife is and then all the educational pathways and regulations. So there's such variations of what is perceived by a local community of what can be done and can't be done by a midwife. So I always find these conversations, like maybe that's part of why they don't want malpractice, because they're going to be held more to a structured box. I don't know. That might be part of the barriers of education. So, anything else, gold gems you'd love to pass on to the midwives? Isi, I really appreciate your time today.
So you actually raised a very interesting question, whether to insure or whether to go bare. And this is always very difficult. Now, of course, I'll give my disclaimer that I'm an insurance agent that sells insurance. So obviously I want to make sales. Although I will tell you 10% of the time I recommend to prospects that they not buy insurance with us, but they take the insurance that their employer offers or that their hospital is offering, or that, there are better choices than what we would have for them. Having said that, the question of whether to take coverage or not take coverage is an intriguing question. So generally speaking, if you're being sued by a really significant law firm that does this day in and day out, they're going to name you and you're going to need to defend yourself. And if you think about it, they're going to name you, probably a hospital, probably an anesthesiologist. So from the well-heeled law firm point of view, they don't have a strong incentive to drop you off the case because you're just one of the people in the case. Also, they may need to find you having committed negligence to also attach negligence to the vicarious exposure or the other pieces that are there. So you may get dragged through this case, whether you like it or not. If you don't have insurance, it may not matter. They may eventually drop you when the hospital decides, or if the hospital decides to settle. But in the meantime, you have choice. If you get named in a suit, the legal fees of getting until you get dropped could be $50, $100, $250,000, or you could just simply fold your sword and say, I'm not going to defend myself. But then, even if you don't have assets, you can land up with a lien against your properties if you have a house.
Long-term,
all these things. So generally speaking, relying on going bare is not wise. Now, if you're doing only home births and there is no other exposure but you, and we see this, many midwives who do only home births have made the decision not to insure themselves, and they tell their patients, I don't carry insurance. That's right. And that's part of their informed consent, that you check the box that says you recognize that. So I think that is probably safer than a midwife who's doing either birth center or hospital births. But having said that, if you're 25, you may not have many assets, so maybe you'll scare them away. On the other hand, if you're 45, you may have equity on your home. You may have other things that ultimately some plaintiff's attorney that wants to be an SOB and wants to win a case because they really feel that they want to win this case may continue a litigation and you find yourself unprotected. I mean, I don't have a year that goes by that a midwife who either with me or with somebody else had claims made coverage and didn't buy a tail finds themselves in the setting where they've been named in a suit. And so you definitely don't want to be there.
Yeah. Well, and it's all about, just like we do for our clients, our consulting and your advice you give, people are going to make their own decisions. And I'm the same way. I'm like, I encourage you to get malpractice, but if you want, because the comment comes up, well, I do home births for the Amish and the Mennonites, and they're lowest of low risk. Like they've had babies, they fall out, they're private. And I said, but if you transport and then something's done on the other end, you're just pooled with everything. Like you have vicarious liability for the transfers just as much as they do for you. And people don't look at it that way. So it's interesting.
And I will tell you, in my years of experience, we have seen those communities sue our insureds. So you may feel that those communities don't sue, but we've seen them.
Yeah. So I think it's just words of wisdom and having people leverage the experts around them. So definitely, if anybody that's listening to this has questions about malpractice, anything, Isi is definitely, I mean, you do so much for our community. So thank you, Isi.
Our pleasure. And really, if you have a question, call Contemporary Insurance Services, ask for me, ask for my son, Eitan. We'll be happy to walk you through the process, whether you buy or not. Wish you guys all the best.
Thank you so much, Isi. Have a wonderful day.
You too. Thank you.